Hello, everyone. My name is Camille Toralba. Today I'm here to talk to you regarding our health law survey for the nurse executive. Discussion number 8 topic that I've chosen today is Pregnancy Discrimination Act. I'd like to tell you about the Act's history and the purpose, as well as the guidelines for the Pregnancy Discrimination Act, employee-employer responsibilities of the Act, and the reporting procedures and penalties for noncompliance. The history of the Pregnancy Discrimination Act begins as early as 1974. In 1974, the United States Supreme Court, Gedelig versus Ililio, ruled on an equal protection case. They ruled that denial of insurance benefits for work loss resulting from a pregnancy without complication was not a violation of the 14th Amendment. And then again in 1976, a Supreme Court ruling in General Electric versus Goldberg held that employers could legally exclude conditions related to pregnancy from employee sickness and accident benefits plans, leading to the United States Congress enacting the Pregnancy Discrimination Act in 1978, which amended the Civil Rights Act of 1964. The purpose of the Pregnancy Discrimination Act can be seen right here in this pic art provided. This pic art has an employer telling an employee, a pregnant employee, I'm afraid we're going to have to let you both go. As you can see, this act calls for women affected by pregnancy or related conditions to be treated in the same manner as other applicants or employees who are similar in their ability or their inability to work. The guidelines for the Pregnancy Discrimination Act include employers that have 15 or more employees, as well as there are no time requirements to become eligible for its protections. Employee responsibility for the Pregnancy Discrimination Act include knowing your federal rights, knowing your local rights, identifying the accommodations needed, and advocating for themselves. The employer responsibility for the Pregnancy Discrimination Act is much more stringent. Employers cannot eliminate a potential candidate based on pregnancy-related conditions as long as she is able to perform the major job functions. An employer cannot refuse to hire due to prejudice against pregnant workers, co-workers, clients, or customers. An employer cannot discriminate against pregnancy in any other aspects such as pay, job assignment, promotions, layoffs, trainings, benefits, or any other discrimination. The reporting requirements for the Pregnancy Discrimination Act include reporting to the Equal Employment Opportunity Commission, who is responsible for investigating charges of job discrimination related to pregnancy. Employees should file a grievance with the EEOC should they feel they have been discriminated against. Penalties for violating the Pregnancy Discrimination Act are quite severe. Maximum civil penalties range from $50,000 for smaller firms and $300,000 for companies with 500 plus employees, varying depending on discrimination offense. In conclusion, I'd like to provide a personal experience regarding the Pregnancy Discrimination Act. This Act's definition includes other related pregnancy, which also includes lactating moms. As you can see by these pictures, I am a mom of four. The picture on the left obviously is my children at a much younger age, and the picture on the right is them about a month ago. When these four were babies, lactating at work was not a positive experience. There was no private room available, much less finding the time away from work to sit in a dirty bathroom to express milk was not ideal. Currently, the Pregnancy Discrimination Act does protect lactating moms from discrimination. However, other current laws have helped to provide a better environment to express milk, enabling moms to breastfeed their babies much easier. And this is the conclusion of this activity, and I just wish you all the best, and please stay safe.